Hey y'all, Daniel Gaines here. I apologize if you hear any wind. It's kind of windy outside today. Just got back home. Got to finish getting things prepared for trial tomorrow. Starts tomorrow anyway. I'm waiting on the last little bit of my evidence to get here. It's actually due here any time so I can get my evidence filed. I hate the fact that I got to do it last minute, but especially whenever I complain because they do it to me. However, I'm a non-lawyer. They are lawyers. They dumped 2,200 pages, more than 2,200 pages of documents on me less than 2 weeks before the trial. I mean, it's to be expected. They knew better than to violate the rules of discovery, but yet they felt compelled to do so anyway. As a result, this is happening. The courts are going to find it extremely difficult to not allow my evidence because of this. In fact, I can actually argue and compel the state to request that the judge allows the evidence. Keep in mind, the state, the Assistant Attorney General on any CPS matter, DCYF matter, part of their responsibilities is to protect the state from any liability. That means that the state engages in any violations of your rights. That means that the state engages in any violations of law. They're actually supposed to speak out about that and protect the state from that liability. Whether it's the ex parte communications they're all guilty of, which subpoenas will be issued soon for those documents, in my case anyway, or it's they speak up about it in court. Either way, they're kind of compelled to do so. But again, that's irrelevant for today. Today's video is more so to talk about something specific. In the state of Washington, because the state's criminally corrupt, and because they're extremely biased against fathers and men, they discriminate based on sex and everything else. They abuse your constitutionally protected rights. I could go on, but gotta save it for trial. I don't want to give everything away. I am going to give something to them now, though. See, in dependency matters in the state of Washington, according to Washington state laws, hearsay is admissible in a dependency trial. You heard that right. The courts allow hearsay as evidence against you to restrict or terminate your parental rights. Most people are going to let that go and let it happen because they lack a proper education on this. So here you go. There's a few issues we face here. One, a dependency matter is related to the custody of a child, is related to parental rights. It is a case that involves purely parental rights. As such, you have constitutional protections according to the Constitution, as well as the U.S. Supreme Court. Well, with that comes protections, including due process rights. Part of that comes down to hearsay. Hearsay can be allowed in court under the Constitution or under federal law and such. Not the Constitution, but federal law. There is ways to get hearsay in. The problem is, it has to be one of the exceptions to the hearsay rule. And in a dependency matter, it does not qualify as one of those exceptions. So if they allow any hearsay, that instantly puts them in violation of my constitutionally protected rights. So every time they mention hearsay, it's going to be objected to. Oh, what grounds can you object to? Well, besides the fact from that it violates my constitutionally protected due process rights, we also have, here's the beauty of it, we also have this thing in the Constitution called the Supremacy Clause. In short, what that says is, basically, The Supreme Court is the highest judicial authority. Federal law is outside of the Constitution. Federal law is the highest authority in the land. The Constitution is the highest law of the land. Then federal laws follows that. States are the low, or on towards the bottom. Okay. It also means that the states cannot ignore federal law, and that the states are actually obligated to uphold federal law before state law. Or if it's contradictory, federal law is what they have to do, because, well, you can't have a state law contradicting a federal law and then using the state law when somebody can use something that's a higher authority. That's just how shit works. Shit rolls downhill, literally, and in the law it does as well. I don't make the rules, I just know them. But then you also have an awful lot of U.S. Supreme Court case law upholding parental rights. One of those cases that is usable in parental rights is Howlett v. Rose, 1990 U.S. Supreme Court. There's a few different things Howlett says that I'll be citing in court to get all the hearsay tossed. One of them, and the fun one, states, oh shit, got to talk when my cigarette went out. Don't smoke, it's stupid. One part of Howlett states that the state courts are not allowed to issue rulings in opposition to U.S. Supreme Court case law and federal case law simply because they disagree with it. Now, that does include disagreements in law, because it doesn't specify. That leaves it open. You can bring that in, and then the Supreme Court would have to get involved before anything would be allowed to continue anyway. But it still kind of screws them whenever there's case law that says hearsay is not allowed. Plenty of it, actually. Quite a lot. So, Howlett v. Rose is your friend. The United States Supremacy Clause is your friend, because when it comes to matters of constitutionally protected rights, the Constitution and federal law take priority over state. That's what the Supremacy Clause says. And when it comes to dependency matters, that's child custody matters. They can try and claim it's not. Ask them what umbrella of the court it falls under. They're going to say it's a dependency court. Yes, Your Honor. What division of the court does dependency courts fall under, Your Honor? Is it criminal court? Is it family law court? Is it civil court? Watch what they tell you. It applies. Don't let these fucks play games with you. That's what they do. Miles Russell's going to find out the hard way tomorrow that playing games, violating rights, violating the law, isn't always a wise option. See, these criminal fucks think that they're untouchable. They think they can hide behind their qualified immunity. They think they can hide behind state laws. They think they can hide by using intimidation and fear against you. The only problem is that hasn't worked on me. They've tried, the state of Washington has tried getting the attorneys I have to exercise control over me because I keep pushing back against the abuse. They're guilty of ex parte communications with the judge. And again, I'm subpoenaing those records. It's with the lawsuit. I just have to wait until the trial's done to date everything and actually file it with the courts. But it's all done. All the subpoenas are done and everything else is. All the documents I'm requesting, all the redacted shit that they put in what they did give me, and then all the shit they left out, intentionally I might add, that's all getting subpoenaed. It's all for the lawsuit. It doesn't end with my trial. It doesn't end. My trial is just where I expose it all. And the beauty of it is, right now, they're supposed to be doing Zoom trials. Those Zoom trials are supposed to be posted on YouTube live, which means if y'all want, y'all have access to watching it through YouTube from the courts, because they're supposed to make it public. And I'm going to tell them I want it made public, because I can waive the confidentiality rights for me and my daughter in this entire matter, because I'm a named party and I have that right. They can't stop it. They can't do shit about it. There's case law to support this. So I'm going to do what I can to ensure that y'all can watch this shit. That way y'all can see what I forced them to admit to, or perjure themselves further and then go to jail for even longer, because I love how the perjury laws are in the state of Washington. Federal perjury laws as well, that as it applies to the states, but sentencing guidelines and stuff like that in the state of Washington, I can rock with that. Y'all should check into that. It's gonna be fun. It's gonna be epic. But yeah, I'm gonna push for it to be posted live like it's supposed to be on YouTube from the courts, and I'm gonna encourage folks to watch it. There's gonna be an accurate record. It's gonna be public anyway. Every damn detail, the documents, all of it. You can't stop it. There's nothing you can do or say to prevent me from doing so. It's all going to be known anyway. So they really don't have no point to try and hide it. But either way, I'm going to expose all these criminal fucks. I'm going to expose the malicious criminal intent of the judiciary, thanks to Terry Farmer. Mainly, it's not just her. It's not just Terry Farmer. Judge Sauerlander, whatever the hell his name is in Mason County. There's a couple other Pierce County judges. They're both involved as well. So it's the judiciary that's the problem in the state. I can't say all the judges because I don't know. I ain't dealt with them all. But thus far, I ain't dealt with any who've been fair. This clown that's going to be doing the trial, we'll see about him. He ain't really had much of an opportunity to. However, I can prove that he tried to stop me from talking one time. I threw his judicial cannons up in his face, made him shut up, and I was allowed to finish my statements. So, looks like, based on that, because you don't get away with telling the judge how to do their job. Not in a court, not in their own courtroom, you don't. And you don't get to make a judge, you don't get a judge to shut up because you told him to, because you get to speak. That doesn't happen. Since this guy actually followed the laws and the rules and everything else, at that moment, he may be fair. And I hope, for the sake of the state, that he is. Because the state's already in enough trouble. There's actually a lawsuit in the Washington State Supreme Court now against the department out of a different county. There's also actually a matter from the same person at the Washington State Supreme Court related to the DCFS agent or caseworker or whoever the fuck it was facing criminal charges. Because they're going to try and fight mine, there's about to be a second one active currently at the Washington State Supreme Court. You think this isn't going to bring attention to the fact that DCYF in the state of Washington is corrupt and criminal? Come on now. I'm not going to let y'all hide the records in my case. I've already proven that. And I don't give a fuck what court order you try and give me. It doesn't have any legal weight over me, bud. I don't fall under your jurisdiction. I also have something called the First Amendment and Supreme Court case law to prove it. It says I can post all these documents as much as I fucking want, and you can't do shit. It's protected. I can show your criminal conduct to the world, and I plan to. And whenever I get all this subpoenaed information, whenever all these subpoenas are sent out and served, and y'all hand over the information you're being forced to hand over, it's all going public too. I want you all to be aware of this. 100% of my emails will be released. Since y'all only filed about, I'd say about 8% of the emails with the courts, and none of them were the early emails. Well, okay, that's an unfair statement. There was 2 or 3 maybe 2, might be 3, but I think 2 out of all of them that actually showed where I was requesting they stop violating the law and uphold my protected rights. Most of those emails where I was requesting that and begging and pleading and demanding for that, those aren't included. The emails that caused me to start recording them, that caused me to stop working with them, that caused me to start asking them to stop violating the law, none of those emails are included in the court documents either for some reason. Kind of odd, isn't it? Why are they intentionally leaving out information? Disconcerting, to say the least. However, it's not left out. At least not in the lawsuit. In the dependency matter, I'm not using a lot of that stuff. I don't need to. Just what they've filed alone, I don't need to file anything. Legit, I don't need to file any fucking documents at all. I can file 0 evidence and 0 documents and entirely prove my case beyond any shadow of a doubt, beyond any reasonable doubt, with 100% certainty, and the courts would be forced to agree that it's 100% certainty. It's like that. Without filing shit. I can do it just on the documents that have already been filed. They've proven my case, but they're still targeting me. But I'm filing evidence. I'm just waiting on this mail truck now. And then I'll have the last one I need. And they're going to like this. Because I'm not giving any rhyme or reason or anything to what my evidence is or for or anything else. The same as what they tried to pull. Same standards. They can't hold me to a higher standard. I'm not a lawyer. I'm doing the same shit the lawyer did. But I'm sure when they see it, they'll realize what a lot of it is. They'll realize, oh shit. And they're probably going to try and get it kicked. Not going to work. You'll fail. I promise. Do keep in mind, I have multiple tricks up my sleeve, up to and including proof of me cussing out this judge. Take from that what you will. I know how it applies and how it affects things. Clearly y'all don't. Look at Terry Farmer. Miles Russell, you allow her to keep violating the law and my rights. You're the AAG for the state. You're supposed to look after the state and then make sure none of this shit happens. You're supposed to stop the state from getting from any liability being incurred upon them. You're supposed to, if there is any liability coming from the state, you're supposed to protect the state from that. And you failed miserably. Miserably failed, dude, in your obligations as an AAG. And the best part is, I'm well aware of it. I've never revealed what all I'm fully aware of. It was only today that I first mentioned this. And I'm intentionally not mentioning things. But see, the thing is, I'm under no legal obligation to do so. I'm not the one who brought the matter. I'm not the one with the burden of proof requirements that have to be satisfied. They are. I don't have to tell them the law or my rights. They're under the same obligation I am. Actually, as a state contracted business, the department, because it's contracted through the state, is legally obligated to know what my rights are and to protect them. However, they're under no legal obligation to tell me what my rights are or the laws. That's my responsibility as a private citizen to know. And unfortunately for them, know them I do. And I know them well, as they're going to learn. Otherwise, I just wanted to address the matter of hearsay in a dependency case. It's easy to get tossed out. It really is. Because it doesn't rise to the level of allowable hearsay. And when you're dealing with matters of protected rights, parental rights, constitutionally protected, the level that the state must show to restrict those rights is a lot higher than it is in a lot of other cases, because those rights are protected. They're fucked. They don't have no evidence against me other than emails where I'm pissed off because they're violating my rights. But yet I have Supreme Court case law I'll be throwing right in their fucking face the first time they try to say that. That's going to eliminate that argument completely from their mouths for good, which 100% removes everything they have against me. Because all they have is my anger at what they're doing to me. And that's not sufficient. Not at all. It's actually supposed to be expected from them. And that, I mean, it's human nature. I have the case law to back this up and support this. So it's not at any of them personally. Well, I mean, there's a few of them I personally dislike, but none of this is personal. Y'all just picked the wrong one. You fools were warned. You were told this when you started violating my rights. I wasn't going to tolerate it. I wasn't going to accept it. And I wasn't going to allow it. I warned you. Actually, at that point, after I initially warned you that it wasn't going to be allowed or tolerated, I kept asking and pleading and begging for you to uphold my rights. After that's whenever I told you that you were going to be facing a lawsuit. Yeah, it was fairly quick, but over about a week and a half, 2-week period. But I don't have to tolerate or accept any of the abuse, let alone prolonged, before I'm allowed to speak out against it. I'm actually obligated to warn you that what you're doing is violations, which is what I've done. I'm also a nice guy and warned you that if you kept doing it, I would be filing a lawsuit. You've made these choices. I just know what to do about your choices. And that's the way it's going to go down. Y'all have a good day. Trial starts tomorrow. I'm going to try and force it to be on YouTube as it's supposed to be, so we can have plenty of court watchers in there. And I'd like to make this, if possible, one of the most watched trials as it relates to dependency or family law in the last 50 years, if we can. There's going to be an awful lot of shit proven. An awful lot. I promise you, it's going to be worth the time. And you'll enjoy the show. Get your popcorn ready, y'all. I'll see y'all very soon.